To give you just another example of how the legal issue is framed, for instance, in cases relating to appointment of judges, uh, where there is a particular article of the Constitution which says that the President shall appoint the judges of the Supreme Court in consultation with the Chief Justice. So in a number of cases, the issue has arose as to what is the meaning and import of the words consultation. Does it mean concurrence, or is it only consultation, a process where the views of the Chief Justice are taken on board and the final call rests with the executive? Now, this is the legal issue that arises in this case. Sometimes it is articulated like that, sometimes it's not so clearly articulated. And then the judge goes on to decide the same and gives his reasoning. Now, identifying the issue and looking at the reasoning part, of course, goes without saying is the most important, because that is the key takeaway of the judgment, which is the essence of the judgment, which is the heart and soul of the judgment. This is the part that is referred to in future cases when people faced with similar fact situations rely on a previous case. So whenever you are reading a judgment, of course, you would speed through the facts. You would, I would say, speed through the irrelevant facts or the immaterial facts. You would speed through the arguments quickly. And what is the heart is the ratio of the judgment, which is reflected in the reasoning. Ratio, as commonly known, is the reasons, the bedrock of the judgment. Ratio sometimes is also the legal principle that the court carves out. For example, there is a case, and this is an oft-quoted example in jurisprudence, where there is a particular law that says vehicles in a particular park are not allowed. And the question is whether a mechanical wheelchair used by a person would qualify as the vehicle or would be characterized as a vehicle in a given case or not. And whether, stated differently, whether when there is a complete prohibition on vehicles entering a park, can a mechanized wheelchair qualify as a vehicle? Can it be allowed or can it be not? This would be the legal question arising in that case. And when the court decides the matter, when the court says, yes, the statute says wheelchairs are not allowed inside the park, but the statute does not go on to define what exactly is a vehicle. But we, keeping in mind the purpose of the legislation, which is to keep the parks out of pollution, out of normal vehicular traffic, to ensure that people can take a stroll in the park without being disturbed, keeping in mind the intent of the legislature when they enacted this particular section. Keeping in mind of all of that, the judges decide in a case that yes, a wheelchair, even if it is mechanized or even if it's electronical, it is not a vehicle for the purposes of the statute, and we go on to hold that. So somebody who's being prosecuted for getting a wheelchair into the park cannot be prosecuted. So once the judges go on to decide that and go on to lay down that legal principle, that legal proposition, which is of general application to future cases, that is what the real prescriptive ratio of a case is. And that is something you should have an eye out for when you're reading a judgment. Because in future, for example, there might be various cases where the court is called upon to decide what is a vehicle for the purposes of that law. And then people would be going back to this decision to say that, yes, vehicle, the word is not defined, but the court in so-and-so case went on to say a vehicle is something that possibly causes disturbance to the people walking or jogging in the park. And on the basis of that analogy, somebody would try to argue their own case. And that is the reason this would be the ratio. And this is something that is important to discern. Karan, with this being the broad anatomy of a judgment, would you like to weigh in?
Well, I think Bharat, you can maybe finish with this, and I'll put in for the 20 minutes that I'll have. I'll get in explaining all what you're talking about.
Sure. Just to finish that thought. So this is the broad anatomy. It is of course easier said than done. I can understand there are judgments these days which run into hundreds and hundreds of paragraphs. Much of this is a problem of I think the Control C and Control V on your keyboards there, because when we research, we sort of tend to go overboard, and then there's a lot of cut, copy, paste that happens, which was not the case, you know, in earlier times when, if you read Privy Council judgments, they lay down the legal principle with such remarkable precision and clarity. And I would personally commend all the people who are looking to understand how to read a judgment, who want to understand how to write a good judgment, to please look at, for instance, Barendra Kumar Ghosh's judgment on common intention in IPC, where the court went on to summarize the law of common intention remarkably in a single line by saying that they also serve who stand in wait. And in one line, the legal principle was so beautifully captured and encapsulated. And that's how judgment used to be written. But today, there is certainly a problem in terms of writing. For example, if you look up a judgment on gender justice, the judgment in all probability would start off with the Vedas, and then other religious documents, and then a number of philosophers who would talk about how important women are to the civilization, as if someone needs scriptures in order to understand that yes, women have to be treated fairly and as equals and respectively, and there should be gender justice. Now, we do not need all these scriptures. We do not need thousands of years of documents to understand that basic thing. One can clearly start with Article 14 or 15 of the Constitution to decide a case of gender justice. But I'm afraid that's not the case, and we are made to try to figure out judgments and try to understand them. Just to give you another example on the problems that we sometimes face in reading and understanding judgments, and this is a phenomena that I call a judgment by thesaurus, where a lot of words are used which do not convey as much. For instance, there is this judgment on a very important topic, on a topic that has great bearing on the citizen of the country. And mind you, ignorance of law, as we all understand, is not an excuse. And judgments constitute important sources of law. So writing a judgment in a way, as I would demonstrate, goes on to put the citizen, who's the primary consumer of a judgment, who's the primary audience of a judgment, in a very, very strange predicament, where you have a judgment against you, which constitutes law, not just with respect to you, but with respect to the world at large. But you cannot really make sense of what the judgment is. So without further ado, I would just get into showing you what one of my favorite examples is on how not to write. Now, this judgment starts like this. This batch of writ petitions preferred under Article 32 of the Constitution of India exposits cavil in its quintessential conceptuality and percipient discord between the venerated and exalted right of freedom of speech and the expression of an individual, exploring manifold and multi-layered, limitless, unbounded, and unfettered spectrums, and the controls, restrictions, and constrictions under the assumed power of reasonableness ingrained in the statutory provisions relating to criminal law. Now, that's just a lot of words. I mean, this is almost anti-self-help. If there was a book which said how to lose friends and alienate people, this would possibly be the beginning or the introduction of that book. I would recommend never write like that. You would be surprised to note that this is a judgment that talks about whether the criminal offense of defamation should be a criminal offense or not, or defamation should only be a civil offense, and giving criminality to the offense of defamation is not something that may be constitutional, as it makes major inroads into the right and the freedom of speech and expression. So something as important and as commonplace as that, written in a fashion which is so difficult to understand. So whenever you are reading a judgment such as this judgment, by the way, was 268 pages. Whenever you are trying to traverse through, please try to steer clear and try to go to the reasoning part and try to understand. I think I'd be failing in my duty if I do not give you an example of how one should write or how judgment should be written. This is a remarkable judgment by a district judge in US, Justice Rakoff, who wrote a judgment, and he started like this. And you tell me if this makes more sense than the one that I read earlier. This is how he started. What a huge debt this nation owes to its troublemakers. From Thomas Paine to Martin Luther King, they have forced us to focus on problems we would prefer to downplay or ignore. Yet it is often only with hindsight that we can distinguish those troublemakers who brought us to our senses from those who were simply troublemakers. Prudence and respect for constitutional rights to free speech and association dictate that legal system should cut all protesters a fair amount of slack. These observations are prompted by the instant lawsuit in which a class of 700 Occupy Wall Street protesters contend that they were unlawfully arrested while crossing the Brooklyn Bridge. Now, the judgment in the very first para catches your attention and gives you the legal issue, very beautifully summarized that yes, this is the case of a number of Wall Street protesters who were protesting against the financial. They were doing a strike, they crossed the street, they broke some rules. But are they troublemakers? Are they people who violated the law? Or are they people who were acting within the broad contours of their freedom of speech and expression? Let's find out. This is how the judgment starts. And this is how judgments, to my view, are supposed to be written, because they are written for the common man, they are written for the student, they are written for people who are bound by that judgment. And it is owed to us to be writing them clearly. I think I'll, at this point, hand it over to Karan. We would come back to how to write better, whether judgments or briefs, a little later in the presentation. Over to you, Karan.
Wonderful. Thank you so much, Bharat, for the insightful view on this. Well, he has spoken a lot of things about reading a judgment. I will just like to, while going through this, also show you how a judgment is to be read. But we're talking about art of judgment reading. Before that, we need to know why do we need to read a judgment in India? So a basic foundational principle that everyone here, I'm sure, knows about, that we are a common law country and follow common law principles. And hence a judicial precedent are following common law principles in the common law country. So how does the judicial precedent is important in India? Is because of the Article 141 of the Constitution of India, the Supreme Court case laws delivered by them are binding on all courts. And apart from that, all the high courts, well, there's no specific section where it says that high court's case law is binding on the lower courts, but because high court is a court of record, under Article 215 of the Constitution, by virtue of Article 227, it has a power of superintendence over the tribunals in their respective jurisdiction. And hence, because of that, the case laws delivered by the High Court has a precedent value in the lower court. Now, the other point here is a lot of people do ask that why is not one High Court's judgment, binding on the other? Well, there's a whole case law history on that. If anyone would want, we'll be happy to share with you our perspective on that. A decision by a high court, it just has persuasive value over the other high courts. It is not binding on them. And there's a whole lot of case law starting from 1975 and following up till now. Now, giving a broader perspective, the foundational principle of why to read a case law, I would like to take you to the current way of reading a case law and how are we researching. So researching is the most important part of reading a judgment. So you will only want to read a judgment which you think is the right judgment for you, which is on the point of law or facts that you are trying to find out. Now, currently, everyone around the world, not only in India, around the world, find case law section from Google. Now, there's nothing to be about that. A lot of people do feel embarrassed about it, but really Google is the best, and the search portal is really good in picking out the right points that we want to research on. And we can write in our own layman language, and then also it pulls out, because it has such a plethora of documents from where it pulls out the judgments. Now, the whole point has been that if you find the right judgment through Google, then what? Now, then you need to have that analytical and comprehension skills to, when you've reached the right judgment, to open it in a law journal or open in an online legal portal, and then go through it to understand what are the real points of that. As Bharat rightly says, that it has different components in a judgment, and I'll come to that point as well. Once you reach the judgment, how do you start reading it has been the biggest point. Do I read the decision? Do I read the first part, the first paragraph? Do I start reading from the middle? How do I start reading it? Now, for a lot of portals and journals, we have a concept of head notes. Now, everyone in the world reads journals, case laws from head notes. And LegitQuest as a company started 3 years back on a premise that head notes are not good to read a judgment. They are good, they are valuable. There's a lot of hard work done by the publisher, but it's not the best way of reading a judgment. Why? Because first of all, head note is an interpretation of the publisher. So the publisher has worked really hard with whatever workforce they had, and they have interpreted the judgment in their own words and written on the top of the judgment so that you can scroll through it and figure out and reach to the right part of the judgment. But a inherent problem with the head note is that because it is an interpretation, the person who's writing it writes in its own language. So, for example, and what is cited in the court of law is not the words in the head notes. Head notes are not cited; they are not precedent value. Precedent value of a judgment is the text of the judgment. So every time when we read a case law, we mark the paragraphs which are in the case law and cite it in the court. So because of this, the head note, the flawed mechanism in a head note is that because it writes in its own words, sometimes those words are not even in the judgment text. Hence, a lot of issues occur, and I have personally worked for so many years, practiced. I have seen that reading head notes doesn't really lead you to the right interpretation of the case. And giving you an example of this is, small example of this is maybe if you're searching for, on any of the portal, if you're searching for infringement of copyright, okay, maybe the portal might open up a case which in its head note has infringement of copyright as one of the lines there. But, and we become very happy. Trust me, when I was a junior lawyer practicing with Mr. Jethmalani, I was very, very happy finding something that he wants, and just, without reading the text of it, the whole of it, I used to give it to him. Then when he used to read every paragraph, every single paragraph, he used to tell me, where is the word infringement, or where is the word infringement in it. So I figured out over a period of time, the word used by the interpreters were not even a lot of time in the text of the judgment, which is a huge problem and hence not cited in the court. This reduces the value of a lawyer in front of judge also. So a very important part of reading a judgment is, now if it makes no sense, we just take weeks and weeks to read them. Now, saying that, I'll come to the next part of the reading. That head notes, according to me, the conclusion is head note is not the perfect way, but we had no other way of reading the case law. Now, as LegitQuest, we have worked on very hard to figure out how is the best way of reading a case law. And we have come out with a feature called iDraft in our legal search portal. I'll just show you how it works. Before that, why is judgment reading such a big task for a student or a lawyer? So trust me, a lawyer with 15, 20 years of experience also has a hard time reading. So every student here, do not have to worry. It's not something which the students are struggling with. It's also the lawyers a lot of time are struggling with what part of the judgment do I need to read, because it's so complex. So the issue really has been that the judgments, case laws everywhere are the most complex form. They are very unstructured, completely unorganized. Every judge or every has a pattern or has no pattern. So the problem is that somebody, as Bharat, it has different components like issue of a judgment, facts of a judgment, reasoning, ratio, decision, arguments, and all of those. So some of the judges would start writing with the argument of petitioner, some write an issue in between, some might write a ratio in the end with the decision. So it's really a very, very complex and unstructured. Now, to break that complexity and that unorganized part of this thing, I, as a feature, came in, and I'll just show you, present my screen and show you how LegitQuest has broken the judgment into different parts, the way a judgment needs to be read. So that the other issue is also, as Bharat rightly pointed out, was that now the previous judgment, like Privy Council, Federal Court judgments, were one of the best judgments. They were precise, like in 20 pages, they will write down law about 55 propositions. Whereas these days, a lot of judgments are really good, but a lot of them, because we have worked on more than 2 million judgments till now, we have found out that a lot of judgment, just write down the case law cited by the petitioners. They cite the case laws by the respondents, And in the end, there's one liner: due to the aforementioned stated principles of law and cases, we deliver the judgment like this. Now, nobody understands that which case law has been cited, which case law has been approved, what is the real ratio of the case, and there is a lot of problem in understanding of it. Now, the components of a judgment are issue, facts, argument of petitioner and respondent, amicus's argument, discussion and interpretations, reasoning of a case law, ratio of a case law, obiter if any. Then there is finding of facts, finding on law. There is majority concurring, minority dissenting, and there's case cited, section and acts involved. So what is the issue of a case? When you start reading a judgment, what is the issue of the case? The issue of the case is why it has come from the previous court to the higher court. If it's in the district court, you already know what the issue is. But if it has come to the higher courts like the High Court or the Supreme Court, it has come on a specific issue. And we have to figure out what this issue has been. And that is one part of it. So I would really recommend everyone to first break down the case law in these components, and it becomes really to read and understand. The second is the facts or brief history. Now, why I say this 1, 2, 3, 4, 5, 6, because this is the trend of a judgment, that it is mostly the issue first, facts, brief history first, then the arguments, then discussion, reasoning, and findings and ratio. But a lot of time it is haywire because there is no, again, it's very complex and it's unstructured. Now, coming to facts, as Bharat said, that facts are why it has come, where it has evolved from, what are the people involved in that. And in appellate courts, facts a lot of time become a brief history of the case also. So it can be facts / brief history, because not every time they're talking about the facts, they're also talking about why the case has come from the previous tribunal or the trial court, or in the Supreme Court, why it has come from the High Court to Supreme Court. They write down the brief history of the whole litigation that has happened, and not necessarily talking about facts too much, because they don't want to again write down all the different things that the lower courts have already written about. Then comes a very important aspect of finding arguments. Now, in the current system of reading case laws and through any medium, you talk about online portals, journals and all, nobody can find argument of petitioner and respondent unless you go through the judgment. It's a very, very tricky work, and it's very time consuming. But we have, through LegitQuest, resolved the arguments part as well. So the argument of petitioner and respondent, you have to, sometimes the higher court really clearly write down that, okay, the learned counsel for the respondent, learned counsel for the appellant has said this. A lot of time when seniors argue in the higher courts, they write down senior counsel so and so submitted. Now the problem there is that you have to first go find out the case order, that this senior lawyer appeared for whom. Has appeared for the petitioner and respondent? That's another big work to be done, which we are trying to resolve. But this is very important. If they write down the lawyer and a lot of time it's not specific in the orders and the judgment, this person appeared for the argument for the petitioner or the respondent, it's a very tough job to find out. Hence, the segregation cannot be done. That, I mean, you need to really read it through. Was he given or a lot of time in civil cases, especially, thing with an evidence through that is how the arguments are given. So it's not straight away written arguments of petitioner respondent, it's by the respondent stated that. So that is also the submission of the respondent, or vice versa, the petitioner. The third important, the other part of this is amicus's argument. Now, once you have an amicus in the case, you have to figure out who the amicus's arguments are leaning towards. Then you make sure that if it's leaning towards a petitioner, you put it in the bracket of petitioner or the respondent thereafter. Then usually comes the discussion and interpretation of the case, where they talk about the cases cited by different parties. They discuss the evidence. It's a criminal case and similar case. And immediately, maybe after that, they write down their reasoning. So discussion, interpretation, and reasoning has a very thin line between each other. Reasoning is why they are giving something. So if they're writing a line of it, why are they giving this saying this, why I prove this. And ratio, basically the ratio decidendi of the case wherein they have said that this law holds good because of so and so reason. So reasoning and ratio again are between overlap with each other. Then a lot of people do ask that what is the difference between arbiter and ratio? Well, everyone knows theoretically, but very simply, in a simple line, arbiter is just an expression, like two judges are talking amongst themselves in the court orally, or they were writing the judgment. So always we give these decisions and everything in a judgment. Some as judges, not me, judges really do write down each other and they have their expressions in the judgment text as well. Now, very importantly, one part of the whole thing which people do not really read through in a judgment is the finding of fact. Now, this is mostly again, this I learned one of the best learning how to not only find the point of laws, but of course have exactly to know which part of the judgment has finding of facts in it. Now, finding of fact is like an example that High Court said that I do not want to believe in PW1 and hence this guy is acquitted. Whereas the Supreme Court said that I completely believe in the testimony one and hence the acquittal has been reversed to a conviction. This one line would be anywhere in the judgment text, but where for a lot of cases to that this is where the real turned around because the finding of fact was in the favor of the accused. Then apart after this, cases with judges have majority concurring, minority dissenting, which means that one judge agreeing for other reasons is a concurring part of the judgment, and if one of the judges is dissenting reason, it becomes the part of the case. So saying this, let me show you the screen and show you how I work. While I just I would the next important part of after segregation of the components of a while reading is done. What are the next steps? Once you have figured out that yes, this is the right judgment for me, is to actually figure all it has been followed. So if a 2003 judgment you think it is good for you factually, law favor, have to where after 2003 it has been cited later. It has been followed, affirmed, approved, what has happened with that judgment. And then you have to be very, very careful of the fact that is it overruled or not? Is it distinguished or not? Because if it becomes bad law and you cannot cite it in court, and if it's distinguished, then you have to be ready that maybe the other side might cite the distinguished case and say that this does not apply to the facts of the case. And you have to be very, very particular finding the case law, the right case law. If you're finding, you have to be really particular that you have to find the case where it has been latest affirmed or approved or followed, and hence cite that case because that case will have all the case laws on that point, which pulls me to another very important topic of case law being per incurium. So per incurium means that if I am talking about maybe a law point of non-compliance of mandatory provisions, and I am talking about a 2020 case law. And in 2020 case law, which I cite in the court, doesn't have one judgment on non-compliance or mandatory provision, which was a 94 judgment or something. Now, the problem is that if the person is citing a case law like the old one, if it was not cited in the previous case, and now I'm citing in 2020, then the case itself becomes per incurium because it is not cited the precedent law. So hence we have to be very, very careful that the case law that we cite in the court should not be per incurium, and it should have followed all the case laws which were on that proposition. Saying this, let me just share the screen with you and show you So I hope everyone can see my screen. And this is the LegitQuest portal. I'll just show you how on this portal, what we are talking about, the iDraft feature, the issue, facts, argument, reasoning, and decision of a case law is being segregated. So this has been done for more than 5 lakh cases now for Supreme Court and High Court. So this is how the case laws have been opened. So let me take a very, very famous case of Rupa Ashok Hurra, which is a 5-judge case. So this is a portal developed for students and lawyers and others to really understand also and shorten their time to read a case law, how issue has been segregated, facts have been segregated, and I can really read a case law in a very, very less amount of time. So this is how the case law looks like. This is the case, a very huge 80-para case. The citation, name of the law is here. Now, if you click on issue here, what I've been talking about, it takes you directly to the issue of the case, which is para 25th. And if we read that whether an order passed by the court can be corrected under its inherent powers and all. And it is from the text of the judgment, hence having precedent value can be cited in the court of law. Now, what are the facts of the case? What are the arguments of the case? What are the reasoning? On just single click, it takes you from one para to another, wherever the reasoning or the ratio of the case or the findings of the case are. Decision, majority conquering, foreign case cited, everything on a single click. Now, apart from this, the other part, what I was talking about, that where this case has been latest followed, cited is through this graph. So if I click here, it tells me in 2019 also in Kantaru Rajivaru's case, this Rupa's case has been cited the latest. So hence I will open this case and figure out and see that which point of Rupa's case has been approved and accordingly cite this 2019 case there. So this is how the case has to be broken down into different points and read the same way. And saying this, my last point will be a very interesting experience that I had, and I understood the power of citing the right judgment in that case. I'll just tell you a little bit of background about that. In 2014, when I was working with Mr. Jetmalani, we had a case called Ashik Hussain Faktu. Ashik Hussain Faktu was in jail for like 15 years before that. He was in 89 convicted of TADA meaning terrorist activities. He was convicted under the TADA provisions. And in TADA provisions, at that time, which is now TADA is abolished right now. So in the TADA provisions, after the court, I mean, the appeal goes directly to the Supreme Court. So the only evidence in the Ashik Hussain Faktu's case, the prosecution was his own confession. And I think section 15 was the section where confessions were recorded in TADA. The confession was the only evidence against him. Now the point was that all the appeals, it came to Supreme Court dismissed Ashik Hussain Faktu's SLP. Then this was in 2008-9, and then after that they came to us in 2012-13. No, the notice was issued in 2008-9, and then the SLP was already dismissed. So a writ petition was filed by the lawyers of Ashik Hussain Faktu in the Supreme Court, writ under Article 32, wherein an SLP is dismissed, but they filed a writ saying that this has important provisions of law and we want an open court hearing. Now the law here is very simple. Supreme Court, once dismissing the case or deliberating on the case becomes final, the procedure is to go for review and thereafter for curative. Review is always in front of the chamber judges. It's not to be in open court. Now in 2015, I think there's another judgment which talks about only the accused having death penalty, the review will be in open court. Barring all those cases, all the other cases are decided by chamber judges. And then the last step is curative. So very interestingly, when Mr. Jetmalani was briefed in this, we thought that it's a gone case. I mean, nobody will hear a writ petition under 32 in the court because the procedure and the law is very plain and simple. Now, the power of the judgment was that when we went to the court, Rupa Ashok Hurra's case is the case which everyone talks about when it talks about curative. So the other side cited the Rupa's case, which we have here. In this, if you see para, I'll just take you to para 15 here. If you see the para, it clearly says, this is the law of 5 judges, which says on the analysis of the ratio laid down by mentions, we reaffirm our considered view that a final judgment cannot be assailed in an application under Article 32. That was it. The other side had to just cite this one point and our case was gone completely, because this clearly says you can't get in Article 32, which otherwise the judgment won't attain finality. But Mr. Jethmalani went down, read the whole case. So there's a very interesting case of A.R. Antule, 1988 to SCC 302, I think. I'm not sure about that well. So when you read the Antule's case, Antule has a concept of ex debito justitia, which means that a wrong should be corrected by the judges themselves. It has different principles in that. So we cited ex debito principle and cited the Antule's case of 7 judge in front of the Supreme Court. Excuse me, could you mute, please? Okay. Yeah, so ex debito justitia is a principle wherein you can correct your own mistake. So we cited that 7 judge case in the division bench of the Supreme Court. And you won't believe, this is one of the cases not many lawyers know, not many people know, but this is the order that I have taken out. This is 2014, wherein because of the Antule's case, Mr. Jethmalani was able to convince the judges that there has been something inherently wrong. So please invoke the ex debito principle and kindly give me an open court hearing. Now, the one statement that the judges, Justice Deepak Mishra and Justice Gowda asked us at that time was that, I hope after the SLP was dismissed, the review was not filed. And due to the briefing of the junior lawyers, we said, yes, there's no review filed and all, and nothing is pending at all. So convinced with the case law that we showed, they made the case to be heard by 5 judges in open court. I will send this order copy also, but it should be read well. Open court. So I'll just read down the words here. We have been apprised by Mr. Jethmalani that the writ petition was not filed. No application for review was filed. We have the considered opinion that the petition is converted to a review due to ex debito principle and should be heard in the open court as expeditiously as possible. So this is the power of reading a case law in the best manner, which has led to a case of writ petition being filed after the final SLP, but still getting an open court hearing. But later on, we got to know when the matter came up that the case, it was a problem because review was actually filed. So we went and apologized to the court, but we were not aware of that. So this is the power of the right kind of judgment. And this is why we need to really, with a lot of focus, read and segregate and interpret a judgment. Well, that's about my submissions on the topic of the judgment reading. I'll give it back to Bharat to talk about writing, legal writing, in which I think nobody knows better than him. Bharat, over to you, please.
Am I audible now, Karan?
Yeah. Perfect.
So I'll be talking about the art of writing any legal document instead of focusing on one part or the other. I've written extensively about art of writing a judgment and I've talked to aspiring judges at length on this. Why should we? So today when I'm talking about art of writing better, I'm talking to the lawyers who will be drafting pleadings. I'll be talking to my friends working in law firms who are giving memos and client opinions. I'll be talking about people who are writing columns and articles. So I'll be talking to all of you. Why write better as a lawyer or as a law student is the question. The answer is very simple, that the entire profession is based on communication. It is about getting an idea across. It's about persuasion. The whole profession is about, for example, convincing a difficult judge if you're a litigator, cross-examining a difficult witness. All of that requires proficiency at language. Lawyers also are storytellers. They have to sell their client's narrative. They have to persuade the judge to come to a conclusion in their favor. And language plays a huge role. So the first part would be mastering language, whether oral or written. I love to take this phrase as an example on the importance of language. Consider this: the phrase "roko mat jane do." Now you can equally say it as "roko, comma mat jane do," or you can also say "roko mat, comma jane do." In both these cases, by the presence of a single comma, the difference in meaning is drastic. Similarly, for instance, saying something like "let's eat grandma," as opposed to "let's eat, comma grandma," makes a world of a difference and can possibly save lives. So good punctuation, good language, good grammar can be very, very important if one has to succeed in the profession. And not just writing well. I think most important is thinking well, because I think it is impossible to separate good writing from good and clear thinking. If you think clearly, you mostly write clearly. So the formula is, if you have to write clearly, you need to think clearly. In order to think clearly, you have to read a lot. So the starting point should be reading as much as you can. Read extensively, read widely. Don't confine yourself to just your law textbooks or your legal works or your legal judgments. Read fiction, read literature, philosophy, history, social sciences. That really adds to your legal writing, because it gives you the ability to express yourself better, have a wider vocabulary at your disposal, have more experiences to talk about. As somebody said very beautifully in the case of fiction, fiction allows you an opportunity to walk into somebody else's skin and walk the town with it. So reading fiction also and literature is very, very important. Now, in terms of a formula, whenever approaching a legal article or a legal brief or a persuasive legal document, approach the issue like this. And this goes out to all the people who are learning to write columns. First of all, think of all the things that you want to say and put them down as quickly as possible. So whatever that, for example, if you're trying to write on something like res judicata, think of CPC, think of writ proceedings, think of other situations in which it may apply, think of whether res judicata applies in criminal proceedings or not. Think of everything that you can think of on a topic and write them down in a non-linear fashion. When I say a non-linear fashion, I mean do not state them in the order of priority, just put them out on the paper, all the ideas that you have about a topic. For example, I'm writing something on tech and law, on why do we need super lawyers in today's day and age. When I have that topic in my head, I put to writing whatever I can think of. I can think of how technology is going to affect criminal law, how AI is going to affect constitutional law, how are we going to look at tax laws differently in the time of data. So whatever hits my head, I produce it down and write it in a non-linear way. When I say non-linear, I do not write it in a priority order of 1, 2, 3, 4, but simply in a format on a piece of paper. Once I've got this down, all my ideas, and let's call this the phase of the madman. So every writing would have 4 phases involved. First would be the phase of a madman, where you let your creative self go untrammeled, where you're putting down all the ideas that you can think of on a piece of paper. The second stage is the stage of the carpenter, the architect. The architect who comes in, who gives an order to your ideas. For example, who would make separate headings for each idea. Under the headings, you would have separate subheadings. Then you would give structure to your thoughts on whatever that you've got together in terms of the creative ideas. The third stage, after we are done with the creativity, after we are done with the broad structuring, then we come to the third stage, which is the stage of you filling in the details, you particularizing what you say, which is the stage when you actually do the writing. So spend maximum time in this stage, but only once you've got the structure, once you've got all your ideas in mind. And the fourth stage of writing, which is the final stage, is the stage of the judge, when you go back and look at what you've written, analyze it critically, and then revisit it, and then do corrections. So for instance, these 4 areas are very important for you to look at when you are writing. Some people say creative writing is a process which has no formula to it, but I differ personally. I think there is a method to the madness. Even in terms of creative processes, you can have formulas, you can have structures and frameworks in which you can write better. For instance, this phase of first the madman to get your ideas on the paper, then second, the architect who creates headings and subheadings, and then the carpenter who comes in and fills in all the details. and writes. And fourthly, the judge who comes in, who revisits the text and looks at it critically and suggests revisions. For example, if you got about 10 minutes to write something and you have to broadly give time to each of those stages, I would say you give out of 10 minutes about 2 or 3 minutes to the first stage when you're just jotting things down, whatever comes to your head. To the second stage of the architect, give a minute, give 4 minutes to the actual process of writing, and then give a minute or two to the final revisions, which is very, very important because, as somebody wise said, that good legal columns or judgments are not written, they are rewritten. So very important for you to keep revisiting what you do and follow this broad structure of writing. I would definitely advise you to follow this formula as well, that if you cannot state out aloud or speak aloud what you've written, don't write it. And that is the rule in simple English, writing and communicating better. The shortest distance between 2 points is a straight line. Be very, very straight in what you have to say. Try to say a lot in lesser number of words. Don't beat about the bush. Go straight for what the idea is and try to communicate it effectively. And also try to avoid certain words. For instance, we use a lot of legalese and jargon in our language. A lot of us use words such as inter alia, which can easily be substituted by the word among other things. We lawyers like to say things such as totality of circumstances. Now, wherever you have to say totality of circumstances, all the circumstances is an equally good substitute. When you are saying prior to, you can easily replace it with the word before. When we say arguendo, even assuming, you can always replace it by saying even if. When you're using a phrase, for example, an adequate number of, you can always say enough. Notwithstanding can be replaced with although in most of the cases. We love to say words such as it goes without saying. If it goes without saying, then you should not say it in the first place. So things such as those may be avoided. When we use phrases such as alienate, transfer, and convey. Now a statute may say it like that when it is defining. When you are writing an article, you can clearly substitute those 3 words, alienate, transfer, and convey, by a simple transfer. When you are saying due and payable, you can easily say just due because it conveys the exact sense. If you are saying give, devise, and bequeath, we say that in a lot of succession matters, then you can easily just get away by saying give. Last will and testament, for example, you can get away by saying will. In many contracts, we use the phrases indemnify and hold harmless. Now you can clearly get away by just saying indemnify, because according to most jurists, there's not much of a difference between indemnity or hold harmless as concepts. Similarly, and this is the last example, where if you write something like liens and encumbrances, please write encumbrances. In most cases, it would mean just the same. And keep your average sentence length to about 20 words or less, because there are studies done, people have thought about it extensively, and they come to the conclusion that it is very difficult for any human being of ordinary intelligence to comprehend a sentence which has more than 20 words. I would also urge you to prefer active voice over passive voice. So instead of saying that she was run over or the car, I mean, important to use active voice where you are saying, I did this, instead of saying this was done by me. So keep that in mind. It makes for much powerful writing. Everyone has an individual manner of expression. There's no formula that fits all, but always remember, never conflate style with substance. Substance is very, very important. Also, you know, you would, as you gradually read along and you read more and extensively, you would develop the art of being able to say a lot in lesser number of words. For instance, I'm reminded of this 6-word story that Ernest Hemingway wrote, which went something on the lines of baby shoes never worn, for sale. Now, the legend goes that he got into a bet with someone and he had to write a short story, which was compelling and very, very moving, but he had to do it in 6 words. So he wrote the story of a woman who is expecting a child and who gets a miscarriage, and everything that they planned and bought for the child is all gone to waste. And he summarized this beautiful, complex story in 6 words: baby shoes, never worn, for sale. So try to get into the habit of writing more in lesser number of words. Also try to avoid, doublets and triplets, as I said. Instead of alienate, transfer, and convey, you can very well just say transfer. Avoid legal labels. If you're writing a judgment, instead of repeatedly saying plaintiff, appellant, you name the party initially, and then you refer to the name as you go along in your legal writing or in your judgment. Preferring numbers in numerals over words is sometimes an easier way to go about it. For example, if you're mentioning the number in your judgment 9,432, it's always good to write it in numerals than writing it in words. Unless, of course, you're signing a check or something, numerals also do. The best thing about them is that you're not cluttering your legal writing. Even in terms of writing otherwise, use footnotes liberally. If there is anything that you consider is not as important, try to consign it to the footnote. Don't clutter the body of your text. And this goes out to the people who would be writing judgments or who are interested in judgment writing. Please understand, whenever you are writing the facts, follow the rule of what I say, CRAM. Write facts, keeping in mind chronology, relevancy, admissibility, and materiality. So just keep in mind that simple formulation when you're writing facts. Also, as I was saying earlier, each fact section should clearly specify who did what to whom. You know, these questions of who, where, when, how, what, and why should be answered in the fact section of your judgment. Use short lists. Whenever you're writing, your first para should be something that should give away the essence of what you are trying to argue, whether it's an article or your judgment. We try to do it like this in our chambers, where we try to prepare every matter as we are, as though it's an elevator pitch, where you have to give away the essence of your case in the 60 seconds that you've got, in the time that it takes for one to travel from the ground floor to the 9th floor. And this works out well because at the end of the day, if you practice in the Supreme Court or the higher courts, you would know that on a miscellaneous day, sometimes 10 or 20 seconds is all that you get in order to make a good case. So prepare your first paras like this. Give away the central idea. You know, having been there myself, I can say with a certain amount of confidence that a judge does not have the luxury of time. He does not have the luxury of leisurely meditating. And normally there is always too much work that one has to do. So just give it to the judge, up in the first para itself. And that really makes his job much, much easier. Now, also important is to, there's this formula of creative writing that we talk about: show, don't tell. Instead of telling something, it's good to show. And in order to show, you take some details and let them do the talking themselves. Do not try to clutter your writing by times and dates unless they are important. For example, if there is a dispute that arose 10 years back and you want to write about it, you can clearly say about a decade back. You do not need to say that on 20th January 2010 at 10:40. Unless, of course, it's a criminal case and the time and the date would become crucial for the decision of the case. So go on with, phrases and words that convey a broad sense of time instead of the specific time. And it's good, if you're, and this goes out to the lawyers and people who are writing columns. If you are writing a legal essay or an article where the idea is persuasion, where you want to put your points across, you are, for example, arguing that a certain judgment is not correctly decided in your opinion. If you want to, write that sort of an essay, then also please take account of the judgments which are against you on that legal issue, because somebody else would be doing that for you if you don't do that yourself. Same goes for pleadings. In your written submissions. In a lot of cases in written submissions, we would take the judgment that we know the opposite side is going to rely on, and we say, this is what the judgment is, and this is what it says, this is how it is distinguishable. And another important area of, another way or another tip for writing facts is to concede bad facts at the very outset. If in your pleading there is something that's going to come and bite you in the back, always a good idea to concede it up front, by saying that although yes, this is what is against me, this is how it does not make a difference to the ultimate conclusion of the case. For instance, we were doing a case where we had the facts against us. Our client had written certain things in writing which were very, very incriminating, and we thought this is going to cost us the case in some ways. So there were two options with us. One is to write our side of the facts and avoid those particular evidences or facts, or we could take them and then say, this is what is against us, we understand that, but this is how it does not make a difference. For instance, this is something that another US lawyer did in one of his cases. He said that my client is somebody who's written certain things. We are not proud of what he said. He's extremely sorry himself. But let us examine whether it makes him a fundamentally dishonest man or not. Or is it only that he said certain things in anger, but he's not an immoral guy otherwise? And that's how he took those facts, which were bad facts against him, wrote them, conceded them, but then took the sting out of them in turning it over onto the opposite side, and to demonstrate, and by demonstrating that this does not make a difference to the final conclusion. Another, and this is where I'll stop and, possibly open it up. We're short on time. When you're writing the reasoning part in any of your judgments or any other documents, and this is especially true for judgments, please follow the rule of LOPP, which is the losing party's position, and also write what I call the FLOPP, which is the flaws in the losing party's position. I think a judgment is written more than anyone else for the losing party, for the losing party to know that this is the ground that I've lost out on, and these are the grounds on which I can file appeal. So it is important for a judgment writer to tell the losing party that, yes, this was your position, I've appreciated it, these were the flaws in your position, and this is why you've lost. Because justice, as they say, should not only be done, should appear to be done. And finally, I've already told you, if you can't say it, don't write it. And finally, I would say that good pieces or pieces of legal writing are not written, they are rewritten. Keep revising, keep revisiting. And with that, I'll just hand it over to you, Karan, for the proceedings.
Bharat sir, I have a question.
Well, Shivesh, could you write the question in the chat board? That is the first instruction. We'll take all questions there. There are too many people. If you could write down in the chat, we'll take it after.
All right, sir. All right, sir.
Thanks, Bharat. Thanks for talking about the in-depth insights on writing. Well, you've already covered all the points. I just want to again talk about one or two fundamentals of the jargons and the words that we use. First of all, very importantly, we have to understand what is legal writing and what is legal drafting. A lot of us do interchangeably use these words without understanding the meaning and without really knowing what it means. So legal writing is a very, very broad term, whereas legal drafting is a very narrow term to be which is used. Legal writing has all these subparts of it. Legal drafting is one of them. Whereas legal drafting is a very, very specific term done for drafting of wills, agreements, and other documents which, which set forth your rights, your liabilities, your duties, your entitlements. All those agreements and everything are a part of legal drafting. Whereas in legal writing, briefs are written, and all the briefs of the courts are written, and they are not drafted. They're written, and like the suits that we write, the SLPs and all that, we write them. Legal writing has a lot of already set things like formats. It has margins, fonts, and everything. It is all decided by different courts in different places where we submit suits. Again, SLPs, complaints, and all that. It is already, the formats are decided. Whereas in the legal drafting, the format is completely up to you. You can write an indemnity clause on top or in between, but a lot of people do follow a structure, but it can be written according to you. It can be written in whatever words, whatever number of pages and language that you would, that you think you have a great hand to. Legal writing consists of using a lot of citations and precedents and section and acts, whereas legal drafting does not mostly use citation precedent. But that doesn't mean that we should not know about citation and precedent when we're drafting a contract or any agreement and all. The contract is drafted within the contours of law, which everyone should be aware of. What is the latest law on this point, or which is the latest law that I should get this clause protecting my client later. The very most important point and the difference between legal writing and drafting is that legal writing mistakes, I personally feel, can be corrected and overcome by oral arguments in the court and all. They can be overcome. I mean, I can find an amendment, say this is not what I meant, I want to change these words and all. Whereas legal drafting, agreements, wills, suits, all of that cannot be corrected. Once you have put in your effort and put in your time to draft a contract which is signed and then stamped and everything is done, the only way there will be no way of correcting it. The only way it will be that if there's a dispute, they're going to the court of law and then it will be interpreted. So legal drafting is very different from the whole writing part. So legal drafting, you have to keep in mind that it cannot be corrected once you have done whatever you've done. So it should be really well prepared. And all the points that, of course, Bharat said, just adding to them, again, the outlines of it. While writing an article, column, brief, everything, you need to know the audience you're writing for. Supreme Court or High Court, the audience is, of course, the High Court and Supreme Court judges. You have to give a bigger perception of the whole case, with agreeing and disagreeing, conceding a lot of things, because you can't get away with if you don't concede this, because the trial court has already taken cognizance of that. Second, very importantly, is the structure of how you write. As Bharat rightly said, the structure has to be in these many words, these many lines, and this is the way to go about it. And non-use of unessential words that he has already pointed out, so many of them. Very concise and specific, very simple language. And at the end, very importantly, you have to be ruthless in editing your stuff that you are doing. I'm reminded of my time with in any big case of black money, where we had senior advocate, late senior advocate Nalin Diwan as our counsel. You won't imagine, he used to make written submission of 4 pages every time we used to go to the Supreme Court. But every single 4-page would take 12 drafts. So if there was a comma mistake or a punctuation mistake or a spelling mistake or anything, he would not approve it till the time we used to sit for nights and all, and they were like 12 to 13 drafts that we had to edit, just 4 pages. That was the way how the seniors of that time were ruthless in their editing. And apart from the last point I would like to make is that, as Bharat said, the civil, conceding is a very good way of turning the case around, which is against you, any factual situation or anything. But in criminal law, usually, you don't concede to anything at all. You write the minimum while you're drafting criminal applications, bail applications, quashing petition, because you don't want to disclose your defense at that time. And also you're waiting for the prosecution to put a case against you. In the end, I would just say that it's the whole thing is a complete preparation, how knowledgeable you are about different aspects and everything. And what is your preparation towards every single brief or a case or legal writing or research or column or anything. It's all about the preparation. Need to have great preparation in doing everything. So with this, I think we are done for it. If any questions, if people can write in the chat, we'll be happy to take it. So do we have any questions, Shahat?
Yes, Mr. Kalia, we have questions coming up.
Okay.
Okay, so we have one question from Kanika. She wants to know, is it advisable for judicial aspirants to read the decision of the court, then go up reading up to the facts, or should they just read in a normal, generic way?
I think Bharat can take this.
That's a good question. Thank you for the question, Kanika. As I said, there can hardly be a formula to reading every judgment. Different judgments are written differently. I would say that you have to read at least the important judgments in their entirety. There is no escape from reading the facts part, because you would not be able to understand how the judges decided and what did they really decide without reading the facts. You need to understand what was the background in which the legal question arose. Because as a judicial officer or somebody taking the exam, you would have to decide cases when you're writing the exam. And unless you can compare the facts and evidence of your case with the facts and evidence in the precedent that we are looking at, it would be very difficult for you to decide it properly. So the most important judgments, the landmark ones, which you come across during your preparation, they have to be read in full. But don't fetishize judgments. Do not try to multiply the number of judgments you read on a point that is non-contentious. I sometimes think that's the mistake that people end up committing. For instance, if there is something that this section is absolutely clear about, then you need not multiply precedent on it. It's only when a precedent goes a step further and lays down a legal principle which is beyond the bare act that you try to look at the judgment closely, remember it, internalize it. In other cases, you may sort of skip the irrelevant parts of the judgment or the judgments altogether.
Okay, thank you, Mr. Chugh. We have one more question. This is direct to Mr. Kalia. Shreya wants to, just a second. Ghanshyam Sharma wants to know how artificial intelligence can help in briefing a court order.
Well, again, a very good question. Not a lot of people do ask us that how have you created the iDraft and what is the artificial intelligence used in that? Ghanshyam, the way we went about it was that we started collating all the judgments, and we manually did. I myself had read more than 1 lakh cases, including Supreme Court and other high courts and tribunals. So apart from that, the whole team has read more than 2 lakh cases manually and segregated them. The artificial intelligence technology is that we used to pull out the issue facts from all the cases, made an algorithm which is AI based. We fed the cases to it, 20,000 cases maybe. Then the algorithm understood that, okay, this is how issue facts arguments are being taken out. Then we sent 500 cases, new cases to the algorithm to give us an output now, what they have understood. It gave us an output which was like 3% success. I mean, arguments and all other different parts was only like 3% correct. Then how AI works is that we worked again on those 100 judgments. We told the system, okay, these are the things that you missed and these are the things should be added because of these reasons. And then again fed 20,000 cases to it. And over a period of doing this, the AI algorithm has reached to a wonderful success rate. So now it understands how, as humans, we take out the issue facts arguments and what are the words and keywords, what is the context. So AI involves a lot of things. It involves contextual analysis and apart from that, the keywords, sentimental analysis. So there are too many things with AI. It's not only feeding the judgment, but also running 3-4 algorithms at the same time to make sure that they know what part of issue facts and arguments is the case. But we still want to reach to a very high level of the success rate through AI. And the another downside of this is that not everyone as lawyer, completely agrees with AI. So we have to give it a manual touch all throughout. They use the AI algorithm, but it always has a manual quality check also. Because AI can help you, but the quality and all has to be checked by our the quality R&D team that we have in our company.
Okay, thank you, Mr. Kalia. We have one more very interesting question. Mr. MP Arora wants to know that sometimes judges of lower courts don't like to look into citations which are submitted by the parties, despite observations to this effect by the Supreme Court. So can an application for contempt of court be filed against the judge in addition to the appeal before the High Court?
Bharat, I think
Mr. Chugh can
Interesting question. Thank you for that. Sure. Thanks, Shahad. Good question. The problem is of, largely more than anything else about the court concerned. Of course, a trial court is also obligated to take into account the settled law on the issue. The law laid down by the High Court and the Supreme Court is the law for the trial courts. And if you are concerned or anxious about the court not taking note of your judgments that you've relied on, it's always a good idea to, instead of just relying on them orally, to file them in the court in the form of written submissions. And sometimes if you formally file written submissions and all the judgments are relied upon, then the court is obligated to deal with them. The court is obligated to apply them if the factual scenario is similar, or distinguish them as the case may be. And if, of course, the court has not dealt with the judgment and according to you, it was applicable in the facts of the case, this is something that can be corrected at the appellate stage, at the revisional stage, and this by itself is a ground of appeal or challenge.
Okay. We have one more question asking, why do we use historical facts and surrounding circumstances as an aid to interpretation of statutes?
So this is slightly outside the brief, but I'll still try to answer it briefly. You go to the external aids of interpretation, as we call them, the legislative debates, the discussions, the law committee reports, in order to understand why the law came to be in the shape that it is. You must have heard of the Mischeif Rule, where if there is an ambiguity in the provision, then in order to understand its true intent, one goes back to the background factors. But that is only in the case where the language of the section is ambiguous, or it leads to absurd results, or there is something or the other wrong with it. And if you apply the law literally, it would either be unconstitutional or it would lead to very, very absurd results. Only in those cases of a vacuum or ambiguity or vagueness that you can go to these external sources of interpretation. But in most of the cases, the section says what it says and has to be taken at the face value.
Mr. Kalia, we have a question for you. Seema wants to know, can you briefly explain the section of foreign cases in the software developed by LegitQuest?
Thank you, Seema. Well, foreign case cited is just like case cited. It means that it takes out what is the foreign case is cited and brings you to that place. We are still working on that because the database is Indian case law right now. So we are trying to make a repository of all the foreign cases cited in the Indian courts. And once that repository is made, we'll be hyperlinking all those foreign case cited. So if you click on them, you'll be able to open them as well. So India relies a lot on foreign law cases at times, like when it comes to negligence, torts, and other things, which is more established outside and more law points have been given outside more than India. A lot of judgments cite foreign cases, and it just refers to the cases cited inside the judgment. That is what foreign case cited means.
We have a question coming up from Abhishek. He's a law student, I guess. He's asking, during law school, we study a minimum of 6 subjects simultaneously, and it is not easy to read every judgment in the method that we have discussed. And we tend to ignore the first principles of law. How should we resolve this?
That's a great question. And that's a concern that I've had, and I think every law student or lawyer has had at some point or the other. There's so many. And that is the reason I said that you do not need to read in full every judgment that comes up in a footnote when you're reading a textbook, for example. Read those judgments which lay down, something novel or something new on that point of law, which interpret a section creatively, which interpret a section differently than in the past. Please skip judgments which are very, very fact-centric, which do not evolve and lay down a principle of law. And you may dispense with reading those and stick to your first principles and your standard textbooks on those points. But even if you're reading more judgments than is necessary, it develops your instinct, it develops an intuitive ability in you to speed read, number one. Second is to understand how a judge writes. So lawyers over their careers read thousands and thousands of judgments, and that's an inescapable reality of the profession. But as you go along, you would realize that some judgments are more important than the others, and you would tend to focus on them. Unfortunately, in India, there is no weeding out of judgments that we don't really need, which should not have been reported in the first place on a periodical basis, which is done in some of the other countries. In India, every judgment, even if it doesn't lay down anything of consequence, is still made reportable, which adds to the bulk of the reportable judgments that we have. We have volumes and volumes of journals of new reported judgments, but not all of them are as important. Most of them, if you look at the head notes, if you look at what they really say, it would not be any different from what has been settled earlier. So, on a case-to-case basis, decide, do you think it is novel or not? Landmark judgments, of course, you cannot escape, for instance, reading Keshwanandan Bharti or Golaknath on basic structure, or the Puttaswamy judgment on the right to privacy. So those, of course, you have to read in full, and others you can dispense.
And I'll just add to what Bharat said, that there's a big problem in the law schools to, first of all, understand what is a landmark judgment. So when we talk about landmark judgment, everyone talks about judgments which are like 5 judges, 7 judges, and 3 judges and all, that they are landmark. Well, the concept of landmark judgment itself is not understood by a lot of people. So landmark judgments are not because they are by more bigger benches of the Supreme Court. Every single judgment, I think it's Article 145, every single judgment of the Supreme Court is binding, of course, and it's a landmark judgment in the sense that in UK and other places, the concept of landmark judgment was over a period of time evolved as the case laws, which were reported by the media. So any case which was reported on the first page or the second or the third of the newspapers was considered to be a landmark judgment. Well, that's not true. You need to read all the judgments, have a great grip on all the case laws. Of course, basic structure and all, you need to understand those concepts really well and need to read those big cases. But all other cases are also given by Supreme Court, are landmark in one or the other way. And adding to this, the other thing Bharat said was about reportable cases. And I would like to add that these days, the courts also write down that the case laws are not reportable, but many journals are even producing non-reportable cases now. Because of that, we also have to do it. Well, I've never really understood why, if the judgment has been said that it's non-reportable, it's still being reported by journals, and people are trying to cite that in the court. And hence it's just adding to the bulk and not giving as much clarity to the law students as well. I think, yeah, that's it.
Mr. Chugh, we have a question for you. Mohammad Arham wants to know, what is the approach while writing an arbitral award? Is it the same that you have discussed, or is there any other approach for it?
That's a great question. Thank you. When you're writing an arbitral award, you are not constrained by a lot of requirements which are there, for instance, in CRPC for writing of criminal judgments and CPC for writing of judgments on the civil side. CPC in some provision tells you what a judgment should contain. CRPC tells you what the structure of the judgment should be, which structure is the same as what we've discussed: facts, the points of determination, the decision on those points, and the reasons for those decisions. Now, this is a structure of a judgment on the civil or the criminal side. An arbitral award, on the other hand, gives much more flexibility to the arbitrator to write in the way that he wants to, because the whole point of arbitration is to move away from the shackles of procedural law and give the maximum freedom for the arbitrator to also conduct proceedings in a way that he thinks is fit and just and fair, and also to write the award. So there are very few restrictions under the Arbitration Act also on writing of an award, but the broad fundamental remains the same, because an arbitral award is also something that can be challenged in the court in a proceeding under 34 of the Arbitration Act. An arbitral award also should show the reasons for the decision and how the arbitrator arrived at those, at the decision. What was the mental process? How did he appreciate evidence? Which witness did he believe? Which witness did he not believe? What documents were found to be credible? What documents were found to be unworthy of belief? So all of that should be demonstrated in the arbitral award if it has to pass scrutiny. So just to summarize, the requirements of formality for an arbitral award is not as a civil judgment or a criminal judgment, which is required to be much more formal. But the basic fundamental of justice seen to be done also applies to an arbitral award.
Okay, so Amit wants to know if we have a decision at hand, how do we get to know whether the same has been challenged for the higher court, or whether it has been reviewed, affirmed, or it has become a bad or a good law?
Sorry, what was his name, Chahat?
Amit.
Yeah, Amit, to find out if the case has gone from a lower court to a higher court, of course, you have different ways to do that. You have the petition number, which either you can put in the journal or the online portal that you have with you, or otherwise put the name of the party and figure out that if it's appealed, if it's there and the decision is given, then it will be in any of the legal online portal. Apart from that, the easiest way is to go to the High Court or the Supreme Court website, whichever court you're talking about. If it was a trial court and it has gone to the High Court, you can just simply write down the name of the party, the year it would be, and then try to retrieve that, though it's a very cumbersome process at this point of time still. But to retrieve the information, if the case has been filed in the courts above, the only way is to go to the website of the different courts. Now, the second part of the question is what is good law and where it has been affirmed and all. It's mostly done by a lot of online portals. It takes a lot of effort to do that because you are able to find out where the case has been cited next in the later years. But to give them the right treatment, saying that it has been referred, followed, and affirmed, takes specialized skills to do that. And as you saw, if you saw on our portal, we have done the infographic feature as well. Well, you can't just state that this is good law or bad law at this moment. We are in the process of developing that technology also that will take out the 1 or 2 lines that this is good law, this is bad law. But at this time, it doesn't exist. What you have to do is simply to follow the case where it was, follow the case to the latest. If it's been overruled or referred or followed, you'll get to know it through the infographic feature that we have.
Weber wants to know, how does a law student starts writing for legal portals and journals?
Well, I think we both can answer, Bharat. I mean, there's no time for you to write. You can write in your first year, second year. It just depends. The more you write, the more clarity comes in your mind. And it's all about clarity of what you really want to write at, is something, if you write more, I mean, if you, as we all say that the more you do something, the more you will know about it. If you keep writing, you will have, keep speaking, taking part in mood, will help you having clarity in your mind, which will in turn help you in writing and structured writing, and then reading a lot of books and taking a lot of webinars like this, wherever people with more experience can teach you if you have any problems. I think there's no time for writing. You can write anytime. But you should do it often so that you have more clarity, and the quality increases by the knowledge that you have. So if you read more and you write more, you will have more knowledge and more clarity, and the time can be anything at any point of
time. We have a question from Palak. She wants to know that Mr. Chugh just mentioned that it is important to read landmark judgments, taking the example of the Keshavananda Bharti case. She wants to know, is it possible just to focus on the ratio of those cases?
Yeah, great question again. The problem is, in order to just get at the ratio of a case like that, you need to read it extensively. In judgments such as Keshavananda Bharti, even the judges who wrote the judgment were hard pressed to find out what really was the ratio, what was the key takeaway, and what was the common denominator in all the separate opinions that were written. So in order to arrive at that, you obviously need to study it in great detail. It's not that you can skip some parts, but a judgment that's as long as that and some of the other judgments, if you think that a commentator of great repute has opined on a given judgment, then you may dispense with reading the entirety of it and not go into those 2,000 pages yourself. But if you are taking the key takeaways from a judgment or the ratio of a judgment, ensure that you are doing it from a legit and a credible source. For example, if you're reading constitutional law, you may rely with faith on what Sirvai has to say about it. And so find out credible sources, and if the ratio is given to you by a credible author and a commentator after analyzing the judgment, you may read from that. But I would strongly recommend, even if you're speed reading, go through the most important judgments yourself. And that I think is important. I would also like to say a word about what the gentleman earlier asked, the previous question. I think I completely agree with Karan when he says there's no right or wrong time. I would also add to it by saying that in order to write well and in order to write, I think the first exercise that you need to do is to find out what you want to write on. For example, there's so much legal writing that's out there. How do you ensure that what you write stands out? So your survey of the existing literature, your survey of what's out there already, and when you look at that and then you identify that there is something that nobody has written about, and that's a vacuum that I would like to fill by giving my view on the law. Once you identify that novel thing that you can write, which not other people have looked at, that is the time when you think you should write about something in order to contribute in a useful way to the literature.
Mr. Kalia, Anvesh wants to know what are the features LegitQuest has for students?
Well, these features are the same as for every legal stakeholder, like the judges and the lawyers and all, whoever is using it right now. One is of course the iDraft feature, which you saw. The other is the infographic feature. Then the UI UX experience is absolutely different. It's non-chaotic, not like the others. Then it has a disposition, which is a filter, which means that the case has been allowed or dismissed or remitted back. You can already filter that and then go to the case law. So you don't have to open a case to find if it's allowed or dismissed. You can already filter it down before that. Maybe you want no work, no pay proposition. You want all the allowed cases. You can just click on the allowed filters. You'll get all the cases which were allowed there. And the other very important and interesting thing made by us is the iDraft in filters now. So if you write down a concept of no work, no pay, and you have to otherwise search through a lot of judgments, open their iDraft and find out if you know that you want no work, no pay in the reasoning of a case. So we have now iDraft in the filters as well. So you can just click on reasoning. The cases where no work, no pay is in the reasoning of that judgment, those judgments will only open up. Now, nobody in the world has given this features, iDraft as well as iDraft in the filters. If you check out all our videos and visit the website, you'll know more about it. And if you're interested, you can write down an email or something. We'll maybe fix a demo for you or your college, whatever is we can do to explain you more about it.
We have a question from Pragya. She wants to know, when writing a judgment, do we write precisely on the matter at hand, or should we start with reflecting on the facts of the case and the material underlying social issues involved in the facts? That is her question.
Sure. Thank you, Pragya. Excellent question again. There's no one size that fits all. For example, in a given case, if you're writing the judgment, you may want to write with what the issue really is at the heart of the case. For example, you may want to start the judgment as the example that I gave you, where the judge tells you that, yes, I have some people before me who are being prosecuted for doing or creating public disorder. And what I need to decide is whether they were actually acting in a way that caused public disorder, or were they merely protesting peacefully, and they should be given the defense, and this should be taken as a freedom of speech and expression. And the judge sets it out at the very first para itself, the two competing narratives, the competing stands that the parties have taken before him. And then the judge goes on to deal with the facts in a more detailed way, where he says, this is what the state says, this is what the defense says, and this is the legal issue, and this is how I decided. It depends on how you want to do it. The first para, if you are making it, something of an essence of the case, then please write it at the very end, after you have understood the case really well, after you've decided the case, after you have really mastered the issue at hand, and then you write the first para as a summarization. Sometimes it's a good idea to start the first para and end it with a question after you say, these are the two competing narratives, let's find out what happens. And then leave it there with a question mark and decide it towards the judgment and as you go along. The problem with deciding it upfront in para number 1 is that then there is no incentive for someone to read the whole of it. And it also appears that you've already made up your mind, and now the entire judgment is going to be reinforcing what you already feel. So my advice to you would be to keep it simple. Just highlight the legal issue or the larger issue in the first para, leave it open, then write down the judgment as it is supposed to be written, the facts, the evidence, the issues, the reasoning, and finally the decision.
There is a question. I don't have the name. There is often a blurred line between obiter and ratio in a case when the passing remark is actually of the law or the facts involved. So how does one test a comment or a line, perhaps, in the case by the judge when such situation arises?
Great question again. Sometimes if the obiter also is not something that is a general comment on society or other things that are happening, but obiter is also on a legal point. In which case, if it is on a legal point, you will have to examine whether that legal point really arose in the case, whether it was necessary for deciding the case at hand. If the answer is no, then it may not really be the ratio of the case and may not have precedential value. In order for it to be the principle evolved in the case or a ratio, it has to be necessary for the decision of that very case before the court. Any observations, even on law, made off the cuff and made just by the way by the judge are not something that has a precedential value. We argue it all the time where we distinguish and we say that in that case, although the court went on to say this, it was absolutely needless in those circumstances.
Not audible, Bharat. Yeah, now it's okay.
Sorry. So in those cases, please examine, even if the observation is on a legal point, please argue that this was not something that was necessary for the judge to decide on. The judge sort of went outside his or her brief when saying that. And if you successfully do that, it would not have precedential value.
Mr. Bharat, we have a very interesting question for you, directed towards you. Shivani wants to know how to keep the write-up less offensive when the topic triggers most of the society. Few topics really offend people, and at that time they forget the true meaning of opinion and they start tagging you. But there are many social issues which should come out. It's for writing blogs or articles.
Great question. When you're writing on a controversial topic, sometimes you have to dilute the way you approach the issue in order to be balanced about it, in order to gather the maximum audience or to gain credibility. To me, the idea of a write-up is to deal with the issues and the arguments and the counter arguments in an objective sort of way, as in an impartial way, where I'm analyzing it not with a political agenda or a particular inclination, but as a student of law who's testing the legality of what is said in a given judgment, for example. And when you are doing that, it's good to be a little temperate in the sort of words that you use, a sobriety in expression. Also, it is good to deal with both sides of the coin. There would be compelling arguments on the other side. You have to deal with them fairly. And it's always good to just leave it out there that this is what the issue is, this is what was argued, this is what the court said, and in your opinion, it is correct or it is not correct, or it does not pass constitutional muster or it does. The idea is to be writing that in a balanced way, in an objective way, in a way where you are not doing what we call as an ad hominem. You are not making an attack on the writers of the judgment personally, or you are not trying to say that they wrote the way that they did that particular judgment because of their own experience. So in those cases, you would have to be balanced and objective in how you approach it, and present both sides equally well. Unless, you know, of course, in certain cases, you would want to put your arguments very, very forcefully, and you would want to express your disapproval to a particular judgment or an act, in which case you can very well do that. It's important for us to critically analyze, but do it in temperate words.
Well, I'll like to add to what Bharat said. Sorry, Chad, who asked the question?
So the name is not.
Okay, fair enough. Okay, just I wanted to add that if you really want to figure out, it's not only related to logs and columns. Lawyer, while they're practicing, do that every single day. So if you're appealing to the next court, okay, from High Court to Supreme Court, we are actually attacking the whole judgment of the High Court. And similarly, when we're coming to High Court, attacking the trial court judgment. As Bharat rightly said, there has to be sobriety and other objective, meaningful sentences to it. As a lawyer, if you read any of the petitions drafted by any of the good lawyers who have great hold of the language and of drafting, it will give you a wonderful experience and give you the right kind of way of how criticism is done for something which has been which has already happened, and then writing it in the right way so that doesn't look it's not offending anyone. We do it all the time. We file any criminal matter, we file a bail or a quashing or any other petition. It's always attacking the prosecution team, the prosecutors, the investigating officers, all of them. And similarly, when we're doing a civil case, we are attacking our opposite side, but we are doing it with a lot of objective way and using the right words, right context, right language. I think if you're able to go to petitions and read them, you will get to know how a blog and all is to be written without getting into too much about offending anyone or being very aggressive through your writing.
Okay, so we have few questions which are quite similar, so I'll just club them.
Sure.
So they want to know that what to do when there is delay from the judge's end, like be it final arguments held like 6 months back or decision on applications which are just pending. What can a counsel do in such a situation?
Well, I think we both would agree that there is no, we are trying to find out some technology, in the sense that use of technology wherein all these processes can be clubbed together, and so that the time taken from one place to, time for the for one argument taking 6 months and then the next date and all that can be reduced. But again, the procedure itself, and apart from that, if you are a lawyer who has asked a question, or when you become a lawyer, you will see that it's both ways. So in a lot of matters, when you are respondent or the defendant, you don't want the case to go on, right? So you a lot of time would go and take dates, which will be given back to you in the other way when you're for the petitioner or when you're for the other side. So the procedure itself and the pendency, the number of judges, it opens up a big debate of the whole infrastructure and the number of judges and all. The next thing you can do is to go and make an application to the higher courts and say that, my case is there. If there is some immediate relief that you want, which has been not given by the court, in that sense, you can go to the higher courts and, of course, put your point through. Otherwise, it's the bigger debate.
Just to add to what Karan said, for example, CPC tells you that you have to pronounce the judgment after a particular time of hearing the arguments. So identify those provisions in the CPC. You can always move an application before the same court that you've heard the final arguments, the judgment's been reserved, and it's high time that the decision is delivered. So make use of those provisions, and you can move a necessary application before the same court, or in appropriate cases, as Karan said, seek the supervisory jurisdiction of a higher court.
Okay, so we'll just take up last question for today.
Mhm.
Anvesh wants to know what carries more weight, precedents or already proven legal principles?
So great question again. Precedent, why do you go to a precedent? I think it goes to that question. You go to a precedent in order to find out the underlying legal principle. You say that in a similar case with similar facts and evidences, the court did X, and now there is a complete analogy in terms of facts in my case also. Please go by the precedent X and do the same in my case. It's an argument by analogy. But if that's what the precedent says, it becomes a legal principle. So these are not two different things if we look at it like that. The judgments also, that's a presumption, would go by settled legal principles. For example, if it is a judgment on quasi-contracts, the court is supposed to know the principle of unjust enrichment and go by it. So the right lens or framework to look at it would be that the judgments go on to build the legal principles. A legal principle is not really a settled principle unless some judgment has said so, or the statute has adopted that legal principle. So ultimately, for example, you would not be able to rely upon a 17th century legal doctrine unless the legislature has enacted it in a statutory form or the courts have accepted it. So precedent and legal principles go hand in hand in that sense.
Yeah, and also a lot of time, a lot of principles are evolved by the case law itself. A lot of time, the interpretation of it leads to some principle, which is either which is mostly given to the legislature to form to make a law on it. I think just to add to what Bharat said.
I think we have covered all the questions. Is there anything else that you would like to add, Mr. Kalia or Mr. Chugh?
That's it for tonight. Thank you.
I think this is wonderful. But just wanted to say thank you to Bharat and all the participants. Go check out LegitQuest, see LegitI, figure out what we're trying to do. And again, thank you, Bharat, for giving so much time today. And we'll put the video of this, the recording of this on the YouTube channel of LegitQuest very soon as soon as we are able to edit and all. Thank you again, everyone. Thank you, Chahat, for hosting this, please.
Great. Thank you so much. Thank you, everyone. We appreciate you being here. Thank you, Mr. Chugh and Mr. Kalia.
Thanks.
We hope to see you again next time.
Sure. Thank you.